Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigator series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Welcome to Angeion's Leading Litigator series. I'm here today with Gordon Cooney, the current practice group leader for litigation at Morgan Lewis, former practice group leader of the class action department. We're very excited to have him here today. Thank you for joining us, Gordon.
Thanks, Steve. Thanks for having me.
Gordon, it's a post-Comcast world. Everything has changed. Tell us how it affects class certification hearings in terms of the content, in terms of the experts, in terms of what happens now that didn't happen prior to Comcast.
Sure, Steve. I mean, obviously, we could talk for hours about the impact of Walmart and Comcast. I guess to boil it down, though, I guess I'd point to four different things. First, it's clear that the bar to class certification is higher, and in particular, the definition of a common question has been elevated significantly by Justice Scalia in the Walmart opinion from what many courts considered was the standard for a common question previously. I guess second, I would point to the fact that it's clear that it's an evidentiary burden on the plaintiff's part, that plaintiffs bear that burden, and that the court needs to look at how the evidence would come in, both from the standpoint of how the plaintiff proves its case and how the defense might put on defenses, and to look at that kind of proof and determine whether it's individualized or common. Third, that there really has to be some analysis of how the merits would be proved to be able to get at the question of, is that proof individualized or is it common? And one area where that's particularly significant, and you see that very, very clearly in the Comcast case, is with respect to experts. It's not sufficient today to simply say, we have an expert who will say X or Y or Z. The plaintiff actually has to put on the expert case and its underpinnings. And then finally, from Comcast, we know that individualized issues of damages, if they are complex and difficult, can themselves be sufficient to cause individualized issues to prominate.
So, two of the things you said, one is that we're much more likely to see a Daubert or Daubert type hearing now, and that there are more individualized damages issues that have to be explored at the class cert stage. How does this affect the economies of litigating a lawsuit from the defense perspective?
Well, I think a couple of things. Clearly, the question of expert testimony, the Supreme Court left open in Comcast the question of whether Daubert actually applies at the class certification stage. But my experience has been the district courts have been reading the tea leaves and understand that they have to do a Daubert or Daubert type analysis of the expert testimony offered by the plaintiffs if that testimony is being offered by the plaintiffs to show that common issues predominate. And so there is clearly a bit more of a record that may be required under the practice today than was true before. The good news for the defense about Comcast and Walmart is the burden is higher. The good news is that we actually look at how the claims or defenses could be proved. But the potential negative from the defense standpoint is it's likely that the class certification determination is made at a bit later stage in the litigation. And that can present a greater issue of expense for the defense to get to the class question. I think the key from the defense perspective is to think about what needs to be provided prior to the initial Rule 26 conference with plaintiffs' counsel and try to come up with a reasonable proposal to get the evidence that's truly necessary for the plaintiffs to get to the class question without having to do full merits discovery. It's clear to me that the rules and the court did not contemplate that we would do absolutely full merits discovery before the class determination is made. But I think it's also clear that if that in a post-Comcast world, it needs to be made at a later time with a bit more of a robust record. The final thing I would say about that, Steve, is I think you're seeing more now motions to strike class allegations at the outset filed by the defense. I think that's partly because of the increased cost to get to class certification. And although I think that's reserved for certain kinds of cases where on the face of the complaint you can see that the legal and factual issues are inherently individualized, or the class question can be resolved without a lot of evidence, it makes sense for the defense to think about a motion to strike the class allegations at the outset of the case.
It's impossible to continue discussing class certification issues without talking about issue classes. What are your thoughts?
Well, I think that's one of the great issues in the wake of the Comcast case, and you're seeing a split of authority in the district courts and the circuit courts on this, with some courts saying you can just have an issue certification. I think that that is a short-sighted analysis. I think if you think about what the class action is intended to do, it's in some ways, it's a substitute for joinder to try to get a case and get claims brought to a judgment. Simply having issue certification doesn't bring a case to a judgment. It may purport to resolve an issue in the case, but the question then becomes, well, what do you do with that resolution? Right. And if that determination can't be used to get the case to a judgment, it hasn't really advanced the ball. You can't take a factual finding in case one and necessarily use it in case two if you don't get to a judgment in case one. And so in any event, I think there are significant problems with the idea of issue certification, and I think we're going to see that play out in the lower federal courts for some time, and ultimately that's the kind of question that the Supreme Court is likely to have to resolve.
I think you're absolutely right. Gordon, I can't thank you enough for your time here today. I think that your insight is invaluable, and I think that all of our viewers, both on the plaintiff side and the defense side, will just take so much from this interview. Thank you again for being here.
My pleasure, Steve. It's great to be here.